All right, good afternoon. I'm Lisa Speaker, and today is June 25. We are here to discuss the new court rules that went into effect on January 1st for family law cases. And of course, the trial attorneys have been having to live under these new court rules under the pandemic. And we thought that had raised some interesting issues for attorneys who are trying to represent their clients properly. I have three wonderful panelists today. Gail Town is a family law attorney in Kalamazoo, and Matt Kachik is a family law attorney in Oakland County. Gail used to be on the Family Law Council with me, and she served for quite a while, and she's still on the amicus committee with me. And Matt Kachik is currently a Family Law Council member. And then last but not least, we have Tim Cole, who is at the State Court Administrative Office. Tim is really going to focus on one of the court rules, the one that has to do with FOC ADR mediation. And he was also one of the people, we did this, the family law section did a tour around the state of Michigan to get back in February before we realized the whole state was going to be shut down. And I guess it was really good timing that we did it before the shutdown. We did a tour around the state to educate trial attorneys about the new FOC ADR court rule. And Tim Cole, I think, participated in at least a couple of different sessions. I know he came to Lansing. I think he might have gone to Grand Rapids or up north as well. So welcome everybody. We're glad to have you here. The way we're going to work it today is we're going to talk first about MCR 3206D, which is the financial form court rule. And then we're going to move to 3229 and talk about the confidentiality document court rule. And then I think we're going to take about half of the time to talk about MCR 3224, which is the FOC ADR court rule. So let's get this show on the road. So let's talk about the financial form. And I'm going to be doing a lot more document sharing today than I normally do, but this is a very document intense session. So I think it'll be helpful for everybody if we can see some of the documents we're talking about. So the first thing I'm going to do is put that financial form on the screen. If I can find it in my, I had it, where'd it go? Okay, well now you have to give me a minute. Matt, I'm going to have you take the lead while I'm looking for the document. I'm going to have you start talking about it.
Sure. So, and I'm just going to err on the side of caution here. Back in January, they created this form, and I think the goal of everyone is they wanted to shift the burden from, rather than you having to send the other side questions and hunt and peck to find out what assets or debts they had, rather the burden they would place on the person to disclose those things, much like if you were filing for like a bank loan or application. And they came up with this form. The number for the form is CC 320. That's going to be on the share screen right now. And if you look in the bottom left corner, you want to make sure you're looking at the right version of it. The version is rev.1/20-version 2. That little version 2 you see down there. That's the form. But this is what Gail and I are basically going to be talking about. And this is this form that we have to disclose and exchange all the documents for. And I'll kick it off to Gail now so she can talk about the first points and how we've been doing this kind of post-COVID as well.
Thanks, Matt. So when when COVID hit, we were just getting used to using this form from my perspective, because it wasn't effective until after the January 1 date, and you're not required to exchange it until 28 days after the responsive pleading is filed. So there were a lot of cases where I hadn't even looked at this form without more specificity and practice until we were quarantined. And so then we had to try to figure out how to use this form. And I think there was a lot of questions about it and a lot of concerns when everybody was quarantined and they were already going through these confusing times. So I see Lisa highlighted the 28 days after service. So I would say that during quarantine, during our shutdown, we've played pretty fast and loose with that deadline when we've been trying to cooperate with each other, because it was difficult to have timely filings being made. Some courts were closed. Some were only open for mail-in documents. Things were taking a lot more time. And, you know, we were allowing extensions for answers. You know, that's typically the responsive pleading would be your answer to the complaint. This is used for custody cases and divorce cases. Parts of it are just custody and divorce. I think that like some of the things that Matt and I talked about that were standout issues in using this form during this time was having some difficulty getting the documents from our clients. And using that technology to get not only the information on the form, but the documents. One of the things that I had to go through because I am on the SCAO Domestic Court Forms Committee, we were going to be looking at this form in March to try to make some adjustments to it now that it circulated in practice. It was on our agenda. We had a couple of questions about it, but because of everything going on and all the busyness that SCAO was going through, we have adjourned that meeting indefinitely. So I will, in the chat, put the email to the court forms email in the chat. So if anybody has questions or comments about this form, that'll be subject to review at our next meeting.
Right. So what you're saying is that if people are having problems with it, they might be able to bring that to your attention, then you could communicate it to the rest of the committee, and maybe we can get some improvements on the form.
Yep. Typically,
okay.
Typically there's a comment period, like 45-day comment period before the committee convenes and they look at the form. I don't have that meeting date right now. So in the meantime, feel free to send it to me. I'm just going to pass it along to the court forms email at SCAO. So I'll let Matt talk about the information gathering piece that we've been having some trouble about. So go ahead, Matt.
Sure. You know, one of the things that I tell all of my clients when they're filling this out is anytime you fill out a number as to a bank account or a credit card statement, I want you to also provide supporting documentation issued by the applicable account holder. And where that becomes difficult is in this day and age of post-COVID, where it's difficult to meet face-to-face. Getting the documents from the clients can be a very time-consuming process. And what I've been telling my clients, first of all, in my personal opinion, and you know, opinions will vary, I think one of the best formats to scan and provide documents is Adobe PDF. It's relatively inexpensive. I'm a computer idiot and I learned it, so I think that it's fairly easy to understand. And if there's anyone that I would recommend, it would be Adobe is the format to move documents back and forth.
And Matt, isn't it fair to say, I mean, there's the information that's required by this form, and we're only looking at the first page right now, and I think you're going to go through some of the other parts of it. There's a lot of information required. Even in the best of times, it's going to be very time consuming for the client to gather up all the pieces that are required.
I completely agree. And as a matter of course, when I file if the client retains me to file and I file the divorce case, one of the first things I do is send the client the form in the mail or via email and say, listen, start working on this. This is going to take a long time. It's like a bank application. And you know, Gail and I will highlight some of the points, but the form specifically asks for certain documents. But even where it doesn't ask for a document, I recommend they provide it, like for supporting documentation for bank account statements, so you can prove it to the other side and then skip that step when the other side says, hey, I need documents to prove this. You've already got them in hand. Go ahead, Gil.
Yeah, and so I do the same thing. This form goes out to them as soon as they've been retained because I know it's going to take them a lot of time to try to grasp this. I want them to have the opportunity to review it and start gathering the documents. I've had a lot of people have a hard time accessing their documents online because they are now all of a sudden working at home and they have to adjust to this pivot and change and try to figure out how to download PDF statements and things like that. One of the issues Matt and I were talking about right now is I've, you know, called my opposing counsel and said, look, my client's been laid off. So one of the things that's required in this form is to give them your last 4 paycheck stubs, give them your last income tax return. Well, one, everybody was extended. Everybody for filing their income tax return that was extended, so they didn't have to file until July if they chose to. I've had people that were laid off or people that were furloughed or people that were otherwise decreasing their income. And so all of those things were kind of in flux, as well as having significant market fluctuations in people's retirements and bank accounts. And so, you know, the court rule, that's not me. But that's nice. The court rule requires you to update these forms, and so in some cases it makes sense to, during this time with so much change evolving, to sit back a little bit and see if we can just extend the time, so we had a little bit more certainty when we filled this out under verified statement and then exchanged it later.
Yeah, and I can't remember if we said this, one of the very first points, and I think this is more important when you have a self-represented litigant on the other side rather than an attorney, but one of the first things it says right there is you're not supposed to file this document with the court. There's a ton of confidential information on here, and if I serve the other side with documents, one of the things I start saying in my cover letters is, listen, this financial information form, which you're going to be required to fill out, please note, do not file it with the court. It's confidential, and we can talk more about this later, but I think especially in this day and age of information being able to be moved and pried upon so easily in the electronic age, the trend really from the court system is for us to try to keep stuff as confidential as possible. Those salacious arguments and mud throwing you think is a good idea to make now, 2 years from now when the family is healed, you wish you had never done that. So I think 9 times out of 10, avoiding and trying to keep stuff as confidential as possible and out of the court record is advisable.
Yeah, and I actually had a case where an attorney filed it with the court. Luckily, it was not made a part of the court file, but it says very plainly on this form, do not file this document with the court, but you are required to file a proof of service that you did exchange it within the time period. I think those time periods, a lot of our courts, at least the courts I'm practicing in, have made it clear to us that they were going to be lenient and not be show-causing people or sanctioning people for violating these specific time periods in these court rules, just given the situation.
Yeah, and to Gail's point, and I think that's a really good point, technically this has to be a notarized document. And I don't know if any of you were lucky enough to attend Lisa's, and Don Wheaton was one of the presenters, an excellent seminar on remote notarizations. But one of the requirements that shocked and awed me was that you have to maintain a video record of that remote notarization for 10 years, which is an extremely expensive data maintenance fee to keep. And so quite frankly, I'll be honest, I've only had a few in-person meetings with my clients where we've engaged, had masks and social distancing. And one of them was a meeting to exchange, review, and finalize a financial information form because my client was not technologically sophisticated, and it would have been a complete nightmare to have tried to do it via internet or on the phone. So, that it was one of those situations like a prenup signing where people do, you might want to think about, engaging in proper cautions, but doing it in person.
On that note, the governor just extended the remote notarization administrative order until July 31st, just to FYI. But my question is, if with the notarization for something that's confidential like this, it has so much private financial information, is the notary just going to be keeping on record that this signature page that we're looking at right now? Or, what is the notary going to have a video of? Are they going to have other pages of this private, financial information? That was kind of just a question I had, that because they have to keep it for such a long time on video. We don't know the answer. I just wanted to point that out.
So a couple of people are, I'm not answering your question, but a couple of people are saying like they've done the notary on the trunk of the car. And likewise, I've done that. Lisa, I was following the e-notarization very closely. It was something that I was trying to figure out how to build into our practice. And we do a lot of estate planning here. And when I saw all the hoops you have to jump through, I just couldn't figure out a way I was going to want to make that happen and keep on file for 10 years. This form that, by the way, you have to supplement to, you have to amend it later. If you do amend it, that also has to be sworn under oath. I don't think it has to be notarized, but you have to have that. I'm under the penalty of perjury clause in there. With that in mind, we've also found with this form, we don't have a lot of room. So people were.
Gail, tell me which addendum what you want me to pull first. Let me just go get it while you're talking about addendums.
Lisa, I can answer your question. It's Sandy. In terms of maintaining the electronic record, if you're using a service such as I use GoToMeeting because I was concerned about Zoom initially and the security issues. GoToMeeting will permit me to download and save to the client file a copy of the video together with a transcript of the video. It can, and you, the way I do it is I record everybody, just like we have everybody on the screen right now. You have everybody on the screen. Whatever on the screen is what gets recorded. And it's really very easy to walk through the steps once you know what the steps are, and then record it electronically. It's like an MP3 or 4 file that you just save in the client file. And we keep our electronic files for clients for longer than 10 years, you know, in terms of storage. So it's really not an issue. You already were required as a notary to keep a notary log, and you're still required to keep that notary log. And I did post on the listserv yesterday what I have given instructions to my office to do when going through the process. And I updated those instructions today for the new executive orders. So if anybody needs them, let me know. I'm happy to share it.
Gail, I'm just pulling up a few of the addendums. There was so many of them. I think if there's a couple that you want me to share, just let me know.
Well, the financial counts is likely going to be one that we would use. So these are addendums that were not part of the original SCAO form. Matt Kobliska had posted these on the listserv and gave us permission to use, right, Matt Kachik?
I don't know if I got permission from him, but I don't even think he's attending this Zoom hearing. So if no one else tells Matt who's here on the Zoom hearing, I don't think we should have a problem.
We're not recording this either, and I don't see Matt Kobliska anywhere.
I don't either.
Okay, this is the financial information addendum. This is the one you're talking about?
Yeah.
For Matt.
So, and this goes to Matt Kachik's mentioning that we need the statements. Like, you're not, under this form, you're not required to exchange the statements for the financial accounts, just the debts and the income information. But we ask our clients to give us this information because the financial accounts not only includes bank accounts, but it's going to include IRAs and 401ks and other defined contribution and investment accounts, which we all know are quite different and that our clients usually don't know the difference of a lot of these. And so we want to check all that information that we put in there. And typically the other side wants to see that as part of the exchange of documents normally anyway. So we coordinate to do that as well. And you're guaranteed to run out of space for sure on just the plain form for the verified financial information form.
And like Gail said, what's important to note is a lot of us lawyers, I think back when we did interrogatories, we would never lump bank accounts and 401ks in the same category. And this form does do that. So if, you know, if there's ever an opportunity to use one of these brilliant, I'll call them a Kobliska addendum, it would be the financial accounts, because if you look at the definition on the form, it's really broad. It covers a ton of stuff.
I'll put up this one too. Yes, they're very nicely done, and obviously people are going to need a lot of addendums. It just shows how much work goes into this. So one last question, I think, before we move on to 3229 about this court rule. It's a lot of work for attorneys. It's even more work for the clients who are, you know, have the wherewithal to gather the documents. What do you see as the benefit of the court rule?
I think that this is a really good start to getting that information exchange going. There's been a lot of cases where you just can't justify exchanging interrogatories. There's been a lot of work put into this, you know, for confidentiality and protection from the Domestic Violence Coalition to make sure that some confidential information wasn't exchanged. But in so many cases, it's like pulling teeth just to get a start of where, like, how much money is somebody earning, where are their bank accounts and things like that, that don't justify doing some significant or boilerplate interrogatories. And I do appreciate that it's a good start to get those discussions going and getting that information back and forth.
And didn't the discovery rules change sometime in the past year where there's a limit on the number of interrogatories you can
Yeah, yeah. In domestic cases, there's 35 interrogatory questions, I believe. So that's changed as well. You have the right to do additional discovery after you exchange the.
But all this financial information is separate and apart from that. So if you are able to get a completed form from the opposing counsel, that obviates a need to have to waste your questions, I guess, is how I would put it.
Yeah, you might not. Well, right. And you might not need to do any additional discovery depending on the situation and what was involved.
Even better, right?
That's what I tell my clients. I say, listen, as much as this is going to be like chewing glass, this is a wonderful, wonderful opportunity to save a ton of money in your case. I mean, think about how much of our litigation costs are just in the process of accumulating information with supporting documentation and providing it to the other side. It's like, it's in a lot of cases, it's a lot of the legal fees. And this is a great, I think that makes it much more efficient. I guess the only last point I just want to squeeze in about the form is everyone should take a very close look at there's a question, it's number 2 on the last page of the form under miscellaneous.
On the main form? Is this on the main form?
Yeah, I'm sorry. Yes, Lisa.
Hold on, I'm trying to pull it back up if I can find it. Go ahead. You keep on talking.
Sure. If on the very last page of the financial information form, the standard form, it has a question under miscellaneous, because I know that there's a lot of lawyers that may not fly spec this when the client fills it out, especially if your client's an engineer type and fills it out really well. And the question says, do you claim any assets or debts that you listed are separate property? If yes, provide detailed information. Well, as a lawyer, I think that's a question that if you're representing a client, you better make sure that the client puts down the proper information on that and doesn't, glaze over it, because in a lot of cases, that's the principal issue of litigation, is whether or not an asset or a debt is considered marital or not. So I just give people a heads up.
Matt, what page are you on?
It's the last page, page 7.
Under miscellaneous?
Yep. Question number 2, right there. It says, do you claim any assets or debts that you listed are your separate property? If yes, provide detailed information about why you think it's separate property. And in my very humble opinion, 9 times out of 10, lawyers should be assisting their clients with responding to that question.
Great, thank you. So we're just going to spend a minute on the confidential documents. We had an amendment to the court rule that went into effect on January 1st. And the list of confidential documents did not change, but how attorneys handle those documents did. So first I'm going to show you what the changes to the court rule were. And let me get this on the screen. So the court rule, oh, that's the actual court rule. I want the changes to the court rule. Order, here it is. Okay, so let's try that. Stop share. Okay. So this is the court rule that was changed, and it puts on the party that they have to identify the documents that are confidential. And if you inadvertently file something without identifying it as confidential, you waive confidentiality for that document. And just to remind everybody, the list of confidential documents is in 3229 as well. I'm going to stop share and do a new share. And that list of documents has a lot of things that we're dealing with: the verified statements and disclosure forms, child CPS reports, psychological evaluations, custody evaluations, medical information. So all these things need to be identified. And I don't know if we have any clerks. There was potentially going to be a clerk from Oakland County joining us today, but I'm not sure if she was able to make it. Is Lisa Sis here? If you are, unmute yourself. I don't think she's here though. If anybody has, do you guys want to share any experience you've had dealing with this new confidential document rule?
Well, I think you just gave the heads up to everybody about the thing that should make us all give pause, which is 3.229B, which says right there, the filer waives any claim of confidentiality to any item filed under subrule A that is not identified as confidential. So my practice, err on the side of caution. If you even remotely think it's possibly going to be confidential, label it as confidential, because there's that saying, you can't put that toothpaste back in the tube. And like I said, I really sincerely believe the trend of the court system and judges is to really try and keep things confidential. I was fascinated by how Gail does it over in Kalamazoo, and I'll let her explain it because I wish they would do in Oakland and Wayne and Macomb what they do in Kalamazoo, and I'll let her explain that.
So a number of years ago, our chief judge at the time had instituted a local policy that they wouldn't accept any attachments to any pleadings or motions. And that was a little controversial for a lot of people, but essentially what is happening there is if you attach anything to a motion or a pleading, they're gonna discard it, they're gonna shred it, it's not gonna go anywhere. In Kalamazoo, everything that gets filed, you know, unless it's a confidential document or a front of the court document that goes in the front of the court file, because verified statements on there, for example. But in Kalamazoo, everything gets scanned into what's called the Odyssey program, and it's online. And only attorneys have access to it with password. You have to apply for access, but anybody can pull those documents off for free.
So what do they do with now with this new court rule? Are they accepting the confidential documents, but they put them somewhere different? Or do you know how they're handling it in your county?
In Kalamazoo, so if you have to file your verified statement, for example. You're not filing the verified disclosure statement again, like we already said. But if you file your verified statement, that's going in the front of the court file. The front of the court file is confidential. That's not going online. Okay. That, you know, like you're not supposed to be filing documents that have social security numbers in them anyway. It's a misdemeanor to file a CPS report or disseminate that.
Yeah.
So it's never been my practice to attach those documents to anything regardless. And while some people do it in other sister counties that I practice in as well, it's just not my practice to attach anything to it. But you know, if I'm referencing existence of something about it in a motion, you know, I will indicate that it's a confidential document that will make it available in the appropriate format as needed. Okay. For example, it might be in camera.
And so then you talk about it potentially in the motion at some level of detail, but not maybe a ton of detail, and make it available for future review.
Right, depending on the nature of it, depending on the nature of the document.
It sounds like Wayne County has a system in place too for the confidential documents. Looking at the chat, thank you, Wanda, for sharing that. If anybody in a different county knows that their county is handling it different, feel free to unmute yourself and let us know. But if not, we're going to move on to Rule MCR 3224. No takers on confidential documents? Okay. So MCR 3224, again, went into effect January 1st. And like I said, the family law section did a tour of the state trying to educate attorneys about the new court rule. And we had tremendous participation from referees from around the state, from a lot of counties. It was a super helpful, I think, event for people to hear from their local counties. But I wanted to do a quick poll, if I can remember how to do this. Okay, so I'm going to launch the poll. You should see 2 questions. Do you see 2 questions, Gail?
Yes.
Oh, good. Okay, so answer the question. Give it a couple more seconds. The votes are still coming in. And I'm about to turn it off. Last 5 seconds. Okay, I'm going to end the poll for now. Share results. So we have, can everybody see the results of the poll? So a lot of people are practicing in counties, it looks like, that have been using the court rule during the pandemic. Well, a lot of people aren't sure. So, and then only a couple of people, I would love to know who answered question 2 as a affirmative. We do have some referees here today, and I would welcome their feedback as well. But first, we're going to hear from Tim Cole from Scale. So I'm going to shut this down. Tim Cole from Scale, so we can talk a little bit about the new court rule and what he can give us, like an overview of the court rule from a statewide perspective. Tim, if you could share what you see as happening around the state.
Sure. Thank you for letting me speak today. I appreciate that. I've enjoyed my other opportunities to speak to the family law section. Lisa mentioned that the Supreme Court approved Court Rule MCR 3.224. And it actually got approved back in July 24th of 1999, and it became effective January 1st. And part of the rule, it says that every circuit court has to have an FOC ADR plan approved by SCAO. And as we speak, every court now has an approved FOC ADR plan. And those were approved by SCAO. In fact, I'm pretty confident all of them got approved prior to the rule becoming effective January 1st. If you had a chance to look at the rule, and it's quite lengthy, it kind of outlines 3 ADR processes. One is FOC, domestic relations mediation. One is what we call facilitative information gathering conferences, or affectionately known as FIG conferences, and joint meetings. FOCs were not required to do all 3. They were only required to provide mediation, either directly or by contract. And within the rule also, there were qualifications that had to be met as established by SCAO. I was pleasantly surprised. Most FOCs, I thought it would take them maybe 4 or 5, maybe even 6 months to, kind of get all the logistical issues worked out, but they really hit the ground running. And I think they were doing okay until the pandemic struck, and then that caused some issues. I know sometimes it's referred to as conciliation, and we're trying to change the mindset on that just for consistency and call it facilitated information gathering conferences. What I did was, SEO, we have a Google group that's called Custody, Parenting Time, and ADR. And it's about 65 people throughout the state who are caseworkers or mediators or referees. And I did a little poll also asking them if they were providing ADR during the pandemic. I got about 20 responses, and of the 20, there were actually, of the 60, 20 responded they were providing ADR, 15 were providing Zoom hearings, and of the 20, 12 were doing FIG conferences. So the thing that we try to stress to the FOCs when we communicate with them is that even though they're doing Zoom conferences, they still are required to follow the court rule. And that would include domestic violence screening, confidentiality requirements, and other aspects of the rule. If you've gone to the Supreme Court website, you've noticed that there's a lot of information out there about COVID-19 and how the courts are supposed to be operating. And they're supposed to move in stages based on certain what they call gating criteria. So the CDC and the state put these out, many of the factors, but like they look at what your population is, how much of that population is over 60 years old, how many beds you have available in the intensive care unit at the hospital, are you cleaning your offices and courtrooms? And then based on that, courts can move through different phases until they finally reach full capacity and full operations. So around the state, you're going to see that certain courts are up and running closer to full capacity while others are still at phase 1 simply because of these gating requirements. So in some counties, they are probably providing ADR services. In others, they're not quite ready to do that yet. I think the Friends have tried to adapt as best as possible using Zoom and other means to carry on the ADR procedures. In some counties where attorneys did want to show up, they moved the ADR session to a conference room and tried to keep people 6 feet apart in the social distancing. The forms that the FOCs are required to use, they're out there on our website if you had a chance to use them. Gail had spoke earlier about the SAO Domestic Forms Committee. Well, we had on their agenda some forms, ADR forms we wanted them to look at based on some comments we received from FOCs in the courts about making some changes. But as Gail has indicated, that meeting was postponed because of the pandemic. And I don't know when they're going to reschedule that, but it's important that we got those forms on the agenda.
So,
So
just a question about, do you have an idea about how many counties have been proceeding with the FOC ADR under the court rule since the shutdown? I mean, I know there's a few that we know about. Do you have any numbers about how many counties are actually actively working under that court rule?
I think I don't have a definitive number, Lisa. I would say that most of them are pretty close to providing the services. A lot of the FOCs refer cases to the community dispute resolution centers, and those have been up and running and using Zoom also.
Okay.
A lot of the counties, like in the northern part of the Lower Peninsula, they weren't affected much at all by the pandemic because they didn't have any cases, any COVID-19 cases, so they were up and going. But we get over towards the more populated areas like Wayne County, Oakland, and others. They're a little bit more behind because of their, the variables that impact the full operations. Like I said, the number of beds available and the people over 60. So, but I think we are moving closer and closer to being under full operations or closer to providing those ADR services.
So we had a question in the chat about, various counties and how they're operating under the court rules. And you did say every county has a plan. I think that was the case back in February when you came and spoke to us in Lansing. One county in particular apparently is having what they're calling conciliation conferences, and they're not allowing the attorneys to participate in those conferences, but the attorneys can attend. And I was wondering from you, does that fit somewhere in one of the options that they can use under the court rule? Or is that maybe a county that needs to work on compliance issues?
Well, the rule says that the attorneys have to be allowed to attend the ADR session, and it has to be by mutual agreement. So they both have to agree to attend, or they both agree not to attend. And the structure of the court rule was put in that way. The logic was we didn't want one attorney showing up and a client feeling like they were overwhelmed. So I'm a little concerned that if somebody wasn't able to attend the meeting, that would be an issue. But the word participate, that's a little bit something we may have to look at. It's not supposed to be a hearing. It's supposed to be, the object really is to try to get the parties to agree. It's not where you take testimony, present evidence, do discovery. It's really supposed to be an ADR process where you're trying to find some common ground in order to resolve the custody, parenting time, and support issues.
Okay. So I have a link that you provided me. I don't know if you want me to share it. It was about
Yeah, that was put out by our Office of Dispute Resolution, and the director is Doug Van Epps. And he anticipated that more and more mediation sessions were going to be held online. So they, Doug and his staff developed this document as guidelines and recommendations for mediators to use. And this can be applied to also FOC offices when they are conducting Zoom or remote mediation sessions.
Oh, great. Is there anything you want to point out in this document, or?
Just some general recommendations about, the importance of maintaining confidentiality, the difference between, face-to-face mediation and doing it this way, and just some reminders of things you want to look for. There's, when we talk to people about this, there's always a concern, how do you know if somebody else isn't in the room? That's a concern. If it's just the parties or somebody else is there. So there are some logistical challenges when you do the online mediation.
So I know I did a webinar on mediations via Zoom on April 16. So when you guys receive the link to today's webinar, you can go back and watch that if you want. It's an hour long. But I also see here in this document that the state has developed that there is a recorded training session by Zoom. So that's also helpful if you think you're going to be participating in one of these, or your clients could be participating in one of these in the near future. Thank you, Tim.
I'm looking to see if there's any questions out there. Does Berry County model fit into the court rule?
That was the question you already answered for us.
Okay.
So it was the word attend versus participate, because it sounds like the court rule says attend.
Yeah.
And so the attorney in some counties are being allowed to participate, and some of them are just able to sit by on the sidelines. And if anybody wants to share, you know, an experience or have commentary about that, you know, the court rules change all the time. And so if there's things that we have issues with this court rule, I know we had a very lively discussion in Lansing. I don't know how it was in other the other sessions that the family law section did, but the Lansing version of it, we had a lively discussion about, for example, the domestic violence issues and the screening and how you do, this is before COVID, but how do you even do the screening, because it has people showing up at the same time, basically sitting next to each other and then getting pulled for a screening. And there was questions about that. There was also questions about objecting to the conciliation recommendation and how, I think there was one part of the court rule where you may not even have received it before the time, like the time to object had already gone by, because I think it was a very short period of time. Let's see what questions we have. But if anybody wants to let me know that they want to raise their hand, or we're happy to get feedback. And I also want to hear from some other referees. So Bob, you experience here. I'm going to unmute you, Bob. You experienced the Lansing one. Do you want to talk about anything that you've been dealing with, at least since the shutdown, dealing with this court rule? Bob Hotchkiss is a referee from Ingham County.
Thanks, Lisa. Good afternoon, everyone. The facilitators have been conducting Fixies pretty much remotely. All of our facilitators, there's 8 of them, have their own personal laptop or county laptops. They have access to MISIS. They have access to the front of the court file. They are sent a letter. The clients are sent a letter to let them know when the Fixie is scheduled for, that due to COVID, it's going to be a remote access conference, either by Zoom or by conference call. We ask them to contact the facilitator to confirm that they received the letter within 3 days, and to provide documentation, which can be uploaded to like a box.com type app, which is secured through the county. So the parties can upload their documents for the Fixie. They're also given the domestic violence screening tool. And by and large, other than the fact that we have some logistical or issues with laptops and with uploading and with toggling back and forth between screens, things have been going pretty smoothly. Attorneys obviously can be involved. We do have our population. I think there are quite a few people who don't have Zoom capability on their phones, or they prefer to do it by calling instead of by Zoom for whatever reason. But I will say we just had a meeting with all of our facilitators yesterday. I didn't get any negative feedback other than the form that we use, which we use the FOC 89, which is the order. And then we use the ADR summary report, which is a SCAO form. So we use all the SCAO forms. There's some issue with the form in terms of how do we fill it in, and we can't do spell check, but those are all technical issues that we're working out. But by and large, there was quite a bit of hesitation on the front end of the COVID-19 pandemic and people participating. There was a little bit of scheduling because we had to reschedule all those people from March 16th or 17th. We had to reschedule them and then schedule them again and then reschedule them twice sometimes till we can get everything up and loaded. We do have some of the facilitators that are coming in the office to do facilitative conferences, but that's pretty rare. In terms of objections, the referees, there's 4 of them. They are also working remotely. They also have their county laptops and are able to access MISIS and front of the court file. We met with that section yesterday via a Zoom conference as well. As you can imagine, with COVID-19, we've adjourned and adjourned twice. We are now starting to get pretty close to being about 3 to 4 weeks out. which is kind of where we were at before COVID. I don't think we're quite there yet, so I'm not going to say that we're caught up. We're not. But we are definitely trending in a good direction. The referees have told me that the objection hearings have gone well. The parties do have the right, if they choose not to have their hearing via a Zoom remote hearing, if they want to come into the front of the court office, our office is open. Obviously, we're limited to 10 people in our lobby. There's a lot of restrictions on wearing face masks and distancing and all that. Our courtrooms, our referee hearing rooms are spread out. They've been reconfigured so that everyone is 6 feet apart. We don't have many people coming in, but in cases where there are a lot of witnesses, where there may be some language barriers because people have a different, they need an interpreter, for example. We have 2 attorneys. Some attorneys, at least initially, in my view, were really hesitant about doing Zoom hearings.
I have a question I'm going to pose to you, Robert, but if any of the other referees that I'm going to call on want to provide their thoughts, I would love to hear it too. Has anybody raised a concern with you with the referee hearings now being required to be put on YouTube Live? Has anybody expressed a concern about that? Because, you know, before referee hearings were obviously in a really small room, technically open to the public, but not really. I don't know if there's been a concern that's been raised at all, or if you've heard about that.
We have not heard, no concerns have been raised by any of the clients or attorneys regarding the YouTube Live. We are aware of that. That came up actually last week. And I don't have an answer for you as to that. Obviously, there's some considerations with regards to confidentiality, and we're talking about children and what's in the children's best interest. And throwing something out on YouTube is risky, although I know there are protections, and I know that the judges, for example, I think some of them use the YouTube and then they delete it right away, and then they keep a copy stored. We don't do that. Obviously, we keep a record of all of our hearings so that they can be, in case anybody needs a transcript. But
right. Thank you, Robert. Matt, did you have a comment you wanted to add?
Yeah, I just wanted to say I'm looking right now at the 3.224A8 on the court rule, and it says, talking about the procedure, it says, provide that attorneys of record will be allowed to attend and participate in. So the court rule right there says and participate in, because as a practicing attorney, and I'm sure almost everyone else on this conference would agree with me, the concept of being able to attend one of these things and not participate is horrifying to me. I mean, what am I supposed to do? Like knock them under the table? Like, I don't, that really scares me. So I do hope, I'm glad the court rule says that. And I hope that the front of the court, people following that do respect that part of it.
So Tim, I have a
can I speak to that, Lisa?
Yeah.
Just as far as the front of the court in Ingham County, we've always allowed attorneys to be present, and we've always allowed attorneys to participate. The word participation, I think, as Tim said, is really kind of a loaded term. In order for facilitators to be able to see if we can reach common ground, they have to kind of take charge. And if you have an attorney who's just rolling over the facilitator and badgering the other party, then we're not getting anywhere. And in those cases, we may need to take a step back and say, look, let's get everything out on the table. And then if you want to, bring something up for your client, or if there's something that your client didn't raise you think is important. So we try to be deferential and respectful to the attorneys in their participation, but we also can't be steamrolled, because then we can't accomplish what we're there to do.
So Tim, if people are encountering counties that are not allowing the attorneys to participate, is that something that we should just bring to your attention? Or, I mean, what's the appropriate avenue to deal with the situation?
I would probably go through the regional administrators first. And if they like, they can loop me in. Bob's right. The word participate, attend is pretty clear cut. You're there, you're not there. But again, this is not intended to be a mini hearing where you're going to cross-examine people and you're going to, try to prove someone's not telling the truth. the objective really and what we want, and I think 99.9% of the attorneys involved with these understand that, is to try to get people to reach an agreement. It's not an adversarial process. It's a non-adversarial process where we hope the caseworker, mediator, facilitator, and the attorneys and the parties are all working together to try to reach some type of custody, parenting time, and support agreement. But yeah, the word participate, you could have 100 different definitions of that. Is that to speak frequently, not speak frequently, introduce yourself? So that's what we're really hoping for, though, is that there's a team effort.
Yeah. I think all I do is appeal from my perspective, from what I've heard from clients who have gone through the process, is that sometimes the clients maybe don't really understand what's going on. And sometimes they just need their attorney to be able to, even if not even advocate for them, but just help them understand what's happening as it's happening. But I don't want to get too far afield. I was going to ask Sahara Housey to unmute herself, if she could just share a little bit in Oakland County with her experience with MCR 3224. I know she's done a lot of cases under that court rule. Sahara?
Hi, good afternoon, everyone. Yeah, actually, I've had a lot of success with my custody and parenting time specialists. We have quite a few. We had done it that way even prior to the passage of the court rule. Obviously, attorneys are free to attend, they're free. And I actually, even prior to the court rule, as Tim said, I would say I don't like it when only one side brings their attorney. And so our order now actually says either both attorneys are going to attend or not. So I think as the attorney coming from private practice previously, that's your job. You represent your client. I think we all acknowledge that. But the idea is an understanding that it's more of a facilitative type of a meeting. The idea is to help parties reach a resolution. Nobody gets strong-armed or bullied. But yeah, I've had a lot of success. And then what happens is when they meet with my custody and parenting time specialist, we get them on Zoom, and then we get them on the record and we do the order as much as we can, especially now.
Thank you. Kathy Omke, I know you put something in the chat, but if you'd be willing to unmute yourself and just share with everybody on the process that Livingston County is using, we'd really appreciate it. She also could be in the middle of something else too, so I don't want to put her on the spot too.
I'm here.
Oh, good. Hi.
I'm your mobile correspondent.
Got it. Well, we know what you look like, so I have a picture in my head.
Okay. Yeah, we've been doing the Fixies by phone because I'm at home working. I have a county laptop that was a dinosaur, so it limps along. And we've had varied success with it. I mean, all the attorneys are usually pretty happy with how the conferences go. I usually talk with the attorneys first, and then I join the litigants afterwards. If there's no DV, if there is DV, then I do the interviews of each of the parties separately, and both attorneys are present for both of the interviews. We do all the screening and stuff beforehand, and I get all the information by email, so I have that before I start.
So do you find it hard to keep everything straight when you're doing it by phone?
Well, it's a matter of process that I've been sorting out, and I think people have been very courteous to each other. They are putting on their best face when they're addressing me, and their attorneys, they know the case better than I do, so I always give the attorneys a chance to ask any questions that maybe the clients forgot to talk about. I do go through the best interest factors with each of the parties so that they sort of know what I'm going to cover in my report, and they have input into whether they would agree, disagree, and why. So that's how I cover it.
Thank you, Kathy. And then before, it's almost time to wrap up, but I saw Yvonne Dietz was on the phone. I think she's over in Wayne County. If she's willing to unmute herself, we'd love to hear about Wayne County now that, in case anybody doesn't know, Wayne County wasn't doing really anything during the pandemic until May 11th. They flipped a switch, and then everything started happening, and they've been going full steam ahead. So hats off to Judge McCarthy, who made that happen. And I know there's a lot of other counties that are still struggling quite a bit. And Yvonne, are you able to share some thoughts with us?
Hi, Lisa. It has actually been 10 years since I worked in Wayne County.
Oh,
No.
where are you now?
I'm in Oakland. So don't mind me. So,
Do you have a different perspective than Sahara?
no, I think Sahara covered it pretty well. I mean, while we all do things a little bit differently, I do think we try and have the same sort of standard approach for basic things like implementing the court rules. But I agree with you. Hats off to Judge McCarthy. I think she's really done a lot to try and get Wayne back online.
I don't know. I'm looking, maybe Wayne's all in hearings and that's, you know, an issue there. Everybody's busy going to their proceedings. If there's anybody from Wayne County, I would be more than happy to have you unmute yourself and share your experience with it since May 11th. But I'm not, the names aren't jumping out of me of who might be from Wayne County. So with that, we're almost out of time. Is there any last questions that anybody wants to pose to our panel about really any of the 3 court rules that we've discussed today? And we did check. There were a couple other court rules that I think could tie into family law, but they were not specifically family law court rules. For example, the new Michigan Rule Professional Conduct about technical competency. And starting January 1st, you have to be technologically competent as well, which is kind of ironic. That right before the pandemic hit, people have a ethical obligation to be technologically competent. And I'm not sure how well that's being abided by, but obviously people who are coming to these webinars are ahead of the curve already. So anybody else have any comments? We'd welcome. And panel, do you have any closing thoughts that you wanted to share?
Well, I have a question, Lisa, to Tim. It was something you and I talked about the other day, because you had indicated to me that SCO had received the ADR plan from every friend of the court in Michigan, and they've all been approved. And I had asked you if they would be published on the website so that the public has access to the plans and we know what each county's plan is.
Yes, our plan was before the pandemic is to put all the ADR plans out on our website, similar to what our Make-Up Parenting plans are like. And so you would go to a county, you click on it, and it would pop up their ADR plan. We got, things are somewhat chaotic right now because of the situation, but that's our intent, what we plan on doing. Someone had a question about a report being completed if the parties do not agree. Real quickly, yes, the report has to be submitted. That's required in the court rule when the parties agree or they don't agree. And I can send Lisa the ADR forms if you like, and we can post them out there for you.
Thank you, Tim. You always have something to say, Matt.
Oh, I thank you for the opportunity, Lisa, and thank you everyone for your time, and thanks for attending.
Thank you to all of you and for attending as well. Okay, have a great afternoon. Bye. I'm going to turn off the recording and then shut this down. There we go.